My name is Jorge Padilla. I'm the head of Compass Lexecon in Europe. I'm also teaching competition economics at the Barcelona Graduate School of Economics and the Toulouse School of Economics. Today, in the next 30 minutes or so, we're going to be talking about the concept of abuse. The concept of abuse from an economic perspective. I want to talk in particular about two topics. First, how do we define anti-competitive conduct as a matter of economics? And secondly, how can we choose or design legal rules, legal standards that would allow us to identify anti-competitive conduct in a way that is objective, that is transparent, and that is unambiguous? Those are the two topics that I want to cover today. Let's start with the first of those topics. What is anti-competitive conduct as a matter of economics? We refer to anti-competitive behavior as those unilateral actions that A, distort the competitive process, and B, reduce long-run consumer welfare. If these two conditions are satisfied, then the unilateral action can be regarded as anti-competitive. If one is satisfied but not the other, then we may have a different sort of problem, but we don't have an instance of anti-competitive conduct that requires intervention by competition authorities or courts. In other words, conditions A and B are cumulative. Let me give you an example. Consider tying. Consider a company that ties two products together, products A and products B. They're sold together. They cannot be sold separately. Consider that that company is the only company that can offer that bundle, that nobody else can offer a bundle that includes both products A and B. Even if their competitors in product A or their competitors in product B are as efficient from a technical perspective, they will not be able to match the price or the offering of the company that is tying A and B. They will offer something different. If that is the case, then the as efficient competitors may be priced out of the market, may be forced out of the market. There is a distortion of the competitive process insofar as competitors in markets A and B are not able to compete with the company that offers the bundle because they don't have the opportunity to offer a bundle. Can that reduce consumer welfare? Yes, it can. If the competitors that are not offering a bundle lose volume as a result of the bundle offer of their other competitor, if they are forced to discount their prices in order to compensate for the fact that they are not able to offer a bundle, then they will not be able to obtain the returns necessary to compensate or to fund their fixed costs. And they will be priced out of the market. They will be excluded from the market, which would allow the company that is tying to increase prices and exploit consumers. Of course, tying may bring about some efficiencies. Maybe some consumers prefer the bundle and are better off by being able to buy A and B together. If those offsetting efficiencies are insufficient to compensate for the fact that tying leads to exclusion and an increase in prices, the net effect, the long-run effect on consumer welfare is negative. Here we would have a practice that satisfies the two conditions that I mentioned above: distortion of the competitive process, reduction in consumer welfare. Under those circumstances, this tying practice is anti-competitive. Consider another example, a situation in which one company is able to invest in quality, improve its product offering. By improving its product offering, it actually steals market share from its competitors, even its as efficient competitors. They may be as efficient in the ability to produce the products in question, but they are not serving the same high-quality product. The company that has invested in quality does steal market share, and not only that, it may force the competitor to reduce its prices to compensate for the fact that it's selling a product that has less quality. As in the case of tying, the competitor may be forced out of the market because the reduction in market share and the reduction in prices that it needs to implement in order to compete may lead to a situation in which revenues are not sufficient to cover the fixed cost of operation. The market will become more concentrated. after this investment race. Prices can go up, and consumers therefore may be exposed to market power for a long period of time. Long-run consumer welfare may go down. But unlike the previous situation, in this particular instance, there is no distortion of the competitive process. Nothing prevents as efficient competitors to replicate the strategy of the company that invested in improving its quality. They can also improve quality. They don't have a product that others don't. They are not in a position to do something that their competitors cannot do. Competitors, if they realize that investing in quality is important to prevail in the market, to survive in the market, will find the resources in order to fund their investment. They may do it with their own cash flows. They may do it with money from banks. We don't have an anti-competitive action in this case, because even if there may be a reduction in consumer welfare, there is no distortion of the competitive process. When is the competitive process distorted? Well, from the previous two examples, it should be clear that the key condition is the condition of replicability. Can as efficient competitors replicate the strategy of the company whose behavior is being under scrutinized? Can they respond to the actions of that company profitably? If the as efficient competitors can do so, if they can replicate the unilateral actions of the company that has been investigated, then consumers' interests will be protected by effective competition. This is why we economists put so much emphasis in the implementation of the as efficient competitor test when assessing whether a unilateral action, the unilateral action of a company, is competitive or not competitive. If the as efficient competitor test is satisfied, then there is replicability. As efficient competitors can replicate what the company that we are investigating did, and then we think that there is going to be no distortion of the competitive process. That's what we conclude. Notice that this condition, replicability, may be satisfied even if the as efficient competitor is not actually doing exactly the same thing than the company whose behavior we are investigating. It may not be able to respond to a tying strategy, a bundle strategy, with its own bundle, but it may be able to compete with an unbundled offer if it's able to reduce prices sufficiently. Whether that would be the case or not will depend on whether the net price that is being offered is above the long-run average incremental cost. In other words, whether that response, that pricing response, is profitable. And that's, again, what the as efficient competitor test does and helps us to analyze. Conduct that harms that harms consumer welfare without distorting the competitive process may be the subject of regulation. We're not saying that consumers should not be protected against behavior that hurts them without distorting the competitive process. But this behavior, welfare reducing as it is not anti-competitive. It's problematic, but not anti-competitive, should be dealt with other regulatory instruments, but not with competition policy. And that is why, in many jurisdictions, including the US, behavior such as a firm charging prices that are supra-competitive is behavior that is not considered anti-competitive, is exploitative, may lead to a reduction in consumer welfare, may be the subject of regulation, but is not anti-competitive because it doesn't distort the competitive process. Prices, in particular high prices, can easily be replicated. Now you would wonder, why are we focusing so much on consumer welfare? Why consumer welfare as opposed to other criterion? Companies should do good just because they should behave well. Now we are saying companies should behave in a way that is consistent with consumer welfare. This has been a long debate in philosophy, in political philosophy. Should we adopt a welfarist criterion or should we use criterions of fairness? We economists tend to think in welfare terms. We think in terms of consumer welfare or social welfare. Rather than asking companies to behave in a fair way, we ask them to behave in the best interest of consumers. And this is, among other reasons, because we think that ultimately what matters is whether a particular policy, a particular legal rule, makes consumers better off. Even if we ask a company to behave fairly, we will say that that is desirable if it increases consumer welfare, if it makes people better off. Now, in many jurisdictions, including the European Union, the behavior of the unilateral actions of a given company are only scrutinized, are only analyzed to the extent that that company enjoys market power. We control the alleged abusive behavior of companies with market power, and we consider that companies that do not have market power, companies that are not dominant, could behave in whatever way they want. And the reason for that is because we think that only dominant companies, only dominant firms have the ability and the incentive to distort the competitive process and distort the competitive process in a profitable way. Ability. Well, dominant companies are likely to be able to undertake actions that cannot be replicated by competitors. Only a dominant firm in a tying market can use tying to anti-competitively exclude competitors that are not able to replicate its strategies. Only a dominant company that owns an essential upstream input can improve the competitive position of its downstream subsidiary by denying access to that input to competitors or allowing them to access that input at very high costs. Dominance implies ability to distort the competitive process. Whether there would be a distortion or not depends on whether there is an incentive to distort the competitive process, hurting consumers. And again, firms without market power are unlikely to have the incentive to reduce quality, to increase prices, to adopt actions that exclude competitors, because they will lose market share. Consumers will respond to those initiatives by walking away and moving to their competitors. Only companies that have a dominant position will be able, after having excluded their competitors, to raise prices profitably and for a period of time, without triggering responses from consumers that would render such strategies anti-competitive. That's why we focus on dominance. Does that mean that dominance is a sufficient condition for condition A above, for the distortion of the competitive process? No, it is not. Certain actions of dominant companies may be replicated by competitors at a reasonable cost. Competitors may be able to invest in quality if the dominant company is investing in quality. Under some circumstances, they may be able to respond to a bundling strategy with their own bundle. And certainly, it's not difficult to respond, at least in the short term, to predatory strategies involving reductions in prices below costs. To the extent that those actions can be replicated, they will be rivalry enhancing, and they would be good for consumers. So, not every single action of a dominant company represents a distortion of the competitive process, because many of those can be replicated and therefore constitute competition on the merits. But dominance is typically a necessary condition for condition A, that is, distortion of the competitive process, and also for condition B, that these unilateral actions that we are analyzing lead to a reduction of consumer welfare. And that's why, contrary to what some economists assert, I believe that dominant firms have a special responsibility, as the European competition law says they do. Dominant firms should monitor that their behavior, that their actions, do not distort the competitive process to the detriment of consumer welfare, because they are the ones that can engage in that type of behavior. So we have covered what, in my opinion, is a clear-cut, unambiguous definition of what constitutes anti-competitive conduct. What we are going to do next is to think about how, in practice, we can move from a set of facts that define or delineate a particular unilateral action into a conclusion as to whether that unilateral action is pro-competitive or anti-competitive. So far, we've been focusing on the top graph or the top chain of this slide. We had a unilateral action. We apply the dominance filter, that is, we only analyze that unilateral action if the company enjoyed the dominant position, and we check two conditions. Is that unilateral action likely to distort the competitive process? Is it likely to reduce consumer welfare in the long run? If the answers to these two questions were yes, then the decision was this practice was anti-competitive. Now, checking those two conditions in particular situations is complex. It may involve, very sophisticated analysis. And if companies have to wait to see how those two questions will be answered in a particular case, there may be issues with legal certainty. Companies want to understand what is legitimate and illegitimate without having to go through complicated economic analysis, at least in most circumstances. And competition authorities, if they want to make sure that their actions and their statutes deter anti-competitive action, want to define legal standards and legal rules that are clear-cut and that can be anticipated with a fair degree of objectivity and transparency by companies so that they can adapt their behavior in order to avoid problems. So we're going to be talking about how legal standards can implement the two questions that I mentioned before. How can they help us assess whether a unilateral action is pro-competitive or anti-competitive? What are the choices? What are the different legal standards? Well, there could be almost a continuum of different legal standards. But let me focus here on the 5 legal standards that are most common in competition law. And I'm ranking them in terms of how interventionist these standards are. On the left-hand side, we have per se legality. That's highly interventionist. That's looking at the form of a particular conduct and saying, based on the form of this particular conduct, without any further economic analysis, we conclude that it is illegal. That's the way that we deal with cartels. At the other end of the spectrum, the least interventionist of all legal standards is per se legality. We look at the form of a given behavior and we conclude this is per se legal. In the middle, we have the so-called rule of reason that characterizes antitrust law in the US for a large variety of practices. The idea there is no presumption. We look at a particular unilateral action and then we have to go through the detailed analysis that I mentioned before. We need to understand whether there is replicability, therefore whether the competitive process has been distorted, and secondly, we try to assess what is the net effect on consumer welfare of that type of behavior. In between the per se rules and the rule of reason, we have rebuttable presumptions. On the left-hand side, more interventionist, the rebuttable presumption of illegality. We conclude that based on the form of a given action, unilateral action by a dominant firm, we conclude or we presume that that behavior is illegal. But that presumption can be rebutted if the dominant company presents evidence that that's indeed not the case. On the other side of the rule of reason, we have rebuttable presumptions of legality. These are the standard legal standards, the most common legal standards used in competition law across jurisdictions. So how do we choose a legal standard? Well, we're going to choose that legal standard that maximizes long-run consumer welfare by protecting the competitive process, subject to a number of conditions. The legal standard has to be administrable. It cannot be that complicated that it cannot be implemented at a reasonable cost. It has to be well-defined so that companies understand what they are exposed to. What are the legal limitations on their behavior? In other words, the legal standard has to satisfy the legal certainty condition. And it has to take into account that its implementation, even if it's in principle feasible from a technical perspective, cannot involve too many resources, because otherwise it would constrain the ability of the competition authority or court to do any other thing. That's the way that we choose standards as a matter of economics. Now that's a complicated exercise. So we need to transform that problem into a simpler problem, a problem that we are in a better position to solve. And in order to do so, and as a preliminary step, we need to understand that for each unilateral action that potentially distorts the competitive process, we may conclude that that action reduces consumer welfare when in fact it doesn't, or we may conclude that it does not reduce consumer welfare when in fact it does. In other words, Competition authorities and courts, no matter how qualified they are, like every other human, can make errors. There are two types of errors. Type 1 errors, which involve intervention when intervention is counterproductive, when the costs of intervention exceeds its benefits. The other type of error is the type 2 error, which implies the decisions not to intervene when actually intervention would be desirable. Type 1 errors prohibit as anti-competitive behavior that is pro-competitive. Type 2 errors permit or allow behavior that is anti-competitive, considering incorrectly that it is pro-competitive. The problem of maximizing or choosing the legal standard to maximize consumer welfare can be transformed into a different problem, a much simpler problem, which is to minimize the expected cost of these errors. If we minimize the expected cost of these errors, subject to the same constraints as before, we would have found the legal standard that maximizes consumer welfare subject and protects the competitive process. And believe me, as I'm going to explain in the next couple of minutes, minimizing the expected cost of error is much simpler than maximizing consumer welfare without this framework in mind. And this is the case because we can order the various legal standards that I introduced before in error terms. Per se legality is a legal standard that minimizes the type 2 error. If everything is prohibited, you can never make a type 2 error because a type 2 error would mean that you are approving something that should be prohibited. Somebody that prohibits all the time doesn't make type 2 errors. Of course, it makes lots of type 1 errors because it prohibits even when it shouldn't. At the opposite end of the spectrum, a per se legality rule minimizes the type 1 errors. If everything is legal, there is no false conviction. But at the same time, it increases significantly the possibility and the likely cost of type 2 errors because everything is treated as legal even when it is anti-competitive. We can order these various standards according to whether they maximize the type 1 error or the type 2 error. And that allows us to choose the optimal legal standard for each type of conduct in a way that is optimal. This is not a unilateral action. I'm considering now price fixing for illustrative purposes. We have a cartel where companies fix prices. They collectively set what are the prices that they're going to charge in the market. What is the likelihood that a price fixing agreement distorts the competitive process? Well, by its very nature, distorts the competitive process. What is the likelihood that it hurts consumers? Well, prices are going to go up. It's going to hurt consumers. So, what is the likelihood of a type 1 error? That we find that a cartel is anti-competitive when in fact it's pro-competitive. We're close to zero. So if there are no type 1 errors, the only thing that we need to do when choosing our legal standard to assess price fixing is to minimize the type 2 errors. What is the legal standard that minimizes type 2 errors? Per se legality. There we have found the optimal legal standard to deal with price fixing. Per se legality. What about above cost predation? Above cost predation would be situations in which prices are low but above costs and cannot be replicated by competitors. Now, in some circumstances, these above cost prices, low prices, may lead to the exclusion of competitors. They may not be replicated by other competitors. Definitely they would be replicated by as efficient competitors, but there may be some competitors that cannot replicate those prices. And as a result of that, market concentration will increase and maybe prices will go up in the long run. And consumers will be hurt. So we may be concerned about some type 2 errors. We may be concerned that we are finding that those above cost prices are fine, are pro-competitive, when in fact they are anti-competitive. But very often, if we adopt a legal standard that finds that above cost prices are predatory, anti-competitive, we may incur in the opposite type of error. We may conclude that the prices are anti-competitive when in fact they are pro-competitive, when competitors could replicate them. And in fact, even if they can't, those prices are benefiting consumers, are actually increasing consumer welfare. Economists have been looking at, for the case of above cost predation, what of the two types of errors is more likely and more costly? And they have concluded that the type 1 errors are more likely and more costly in this case. That the risk of adopting a rule other than per se legality with respect to above cost predation would be that we would chill aggressive price competition, and that would generate very significant type 1 errors. We would conclude that prices are anti-competitive, and we would force companies to increase prices when we shouldn't. Because all that they were doing was competing aggressively. If you go through the various different types of abuses, the different types of behavior that in various jurisdictions have been analyzed as potentially problematic, you can use this logic, the error cost framework that I'm describing here, to find what would be the optimal legal rule for each and every one of them. That analysis would allow you to conclude that in the case of refusals to deal, the optimal legal standard is a rebuttable presumption of legality. The company should be given the privilege to say no, even if they are dominant companies, when somebody asks them to grant them access to their essential inputs, unless that presumption of legality can be replicated, because the distortions in the competitive process and the harm to consumer welfare resulting from that no more than offset the benefits of allowing a company to retain property of its own assets. That is the optimal rule. I'm not going to spend time explaining this today. In the interest of time, what I'm going to tell you is that you can do that mapping between legal standards and the various different types of unilateral action the competition authorities analyze in simple terms. I've done that in various papers, in various analyses, and the conclusion is summarized in this slide. We saw that price fixing should be dealt with a per se legality standard. We saw that above cost predation should be dealt with a per se legality standard. You can replicate the analysis to conclude, for example, that time should be considered a rebuttable presumption of legality, because very often the efficiencies generated with time exceed its likely anti-competitive effects. And therefore, we need to bias the legal standard to deal with time to treat time with favorable eyes, while recognizing that there are some exceptional circumstances under which time can be anti-competitive. The same applies to margin squeeze. The same applies to refusals to deal. At the other end of the spectrum, when we look at, for example, exclusionary loyalty discounts, we may conclude that the likelihood that those practices result in a distortion of the competitive process and a harm to consumers is very high. And while recognizing that there may be pro-competitive scenarios, we may conclude, and I think that we ought to conclude, that they are more likely to produce anti-competitive effects than pro-competitive effects. As a result, the adoption of a per se legality rule would be unjustified, much less the adoption of a per se legality rule. We need to start with a presumption of illegality, but we need to allow the dominant company to try to rebut that presumption of illegality, showing, for example, that the magnitude of those loyalty discounts is not so high that they cannot be replicated. That is, allowing the dominant company to implement an as-efficient competitor test to demonstrate that there is no distortion of the competitive process. Or showing, instead, that even if there is exclusion, if the company in question tried to increase its prices, then entry would take place immediately, and therefore it would not be able to exploit the monopoly that the loyalty discounts have allowed it to create. In those circumstances, the presumption of illegality would be rebutted. Now, you would wonder, by looking at this slide deck, that I have not connected any of these practices to the box rule of reason. And especially if you come from the US, you would be surprised that I'm doing so, because many of these practices are analyzed under the rule of reason in the US. Why do I do so? Why have I excluded the rule of reason? The reality is because I think that in practice, the rule of reason is very hard to implement. The rule of reason requires a simultaneous assessment of pro-competitive and anti-competitive effects and a balancing of one and the other. That balancing exercise is very complicated, largely because we economists have failed to provide competition authorities and courts with the tools to do that balancing. We have developed models that allow competition authorities and courts to assess when a given practice may produce anti-competitive effects. We have even developed models that allow to quantify those anti-competitive effects in some circumstances. We have developed stories, rationales for why a given practice may generate efficiencies. And we may have even developed at sometimes evidence to quantify those efficiencies. But we have not developed models, analytical tools that allow you to put everything together to shake the mix and conclude the net effect is pro-competitive, the net effect is anti-competitive. And this is why, in practice, most rule of reason analysis end up with the following two situations. In one scenario, the competition authority or court concludes that there are lots of anti-competitive effects and practically no efficiencies, so it's a 10-0 result, or that there are no anti-competitive effects and there are lots of efficiencies, a 0-10 result. But hardly ever you find a rule of reason analysis that says there are some anti-competitive effects, there are some efficiencies, and the balance goes in this direction or the other. That's why I believe that the rule of reason is not really a pragmatic legal standard, and I've been more in favor of using either per se rules or most often, in most cases, rebuttable presumptions. The previous slide reflected my view about what are the optimal legal standards. How does that compare with the actual legal standards if we focus, for example, in the European Union? Well, price fixing is per se legal in the European Union. Above cost predation is basically per se legal in the European Union. If we look at below cost predatory pricing, it is analyzed as under a rebuttable presumption of illegality in the European Union, so the actual standard coincides with the optimal standard. Refusals to deal are analyzed as rebuttable under a rebuttable presumption of legality rule in the European Union. We call it the exceptional circumstances test or the Bronner test, and that is the optimal rule. So far, so good. But there are some discrepancies in how loyalty discounts are treated in actuality relative to how I believe that they should be treated if we applied our optimality criterion. There are some instances in which the actual and the optimal legal standards don't coincide. One of those is loyalty discounts. I mentioned before that I think that loyalty discounts should be treated as a rebuttable presumption of illegality. And I think that to some extent that's the way that the guidance of the European Commission says that we should treat loyalty discounts, and perhaps is the right interpretation of the recent Intel ruling of the European Court of Justice. But there are many previous cases, and many that opine, that loyalty discounts should be treated as per se legal. That's what the General Court did or said in the context of Intel before its decision was reviewed by the European Court of Justice. I mentioned before, when I was describing optimal standards, that margin squeeze should be treated as a refusal to deal, as a constructive refusal to deal, according to a rebuttable presumption of legality. That's what I believe is the optimal legal standard for the assessment of margin squeeze practices. That is, for the assessment of prices for inputs that are considered excessive relative to the price of the downstream market where those inputs are used. The guidance of the European Commission indicates that the way to treat margin squeeze is as a constructive refusal to deal using a rebuttable presumption of legality. Yet, that's not the law of the land. If you look at what the European Court of Justice said in TeliaSonera, well, the European Court of Justice suggested that the right way of looking at margin squeeze is a rebuttable presumption of illegality. My conclusion, there is a problem with the case law. The case law does not reflect optimality. The actual legal standard is likely to lead to too many prohibitions from the sake of consumer welfare. If you look at time, you will find that in the Microsoft decision, time, basically let me correct, it's not the Microsoft decision, but the ruling of the General Court in Microsoft, and then the Court of First Instance, that ruling deals with time as per se legal. Whereas, if you recall my previous slide, the way that I consider that time should be analyzed is again as a rebuttable presumption of legality. After all, time is a form of refusal to deal. In time, what the company that is tying is saying is, if you want to buy this product, you have to buy it from me and you have to buy it with this other. You cannot mix and match. I deny you the possibility of mixing and matching, of combining my products with the products with your products. The guidance of the European Commission suggests that time should be considered under the rule of reason. That I would disagree with also. I think that time is similar as a matter of economics to refusals to deal and should be analyzed under a similar legal standard. Why? Because time is ubiquitous. Time in most circumstances generates more efficiencies than potential anti-competitive effects. The main concern when we are considering time practices, therefore, should be to minimize the type 1 error. We cannot adopt a per se legality rule, because under some circumstances, time strategies will distort the competitive process and hurt consumers. But those circumstances are the exception rather than the rule. We have seen, therefore, that we can define properly, rigorously, objectively, and transparently what constitutes anti-competitive conduct. We have seen that anti-competitive conduct, therefore, is conduct that distorts the competitive process and hurts consumers. We have seen that we can design legal standards that allow us to discriminate between competitive and anti-competitive conduct, providing legal certainty and obtaining positive results in terms of consumer welfare. We have seen that the right way of doing so is by thinking in terms of what would be the errors that would result from the implementation of this legal standard, and choosing the legal standard that minimizes the likelihood of error. The framework that I have presented today allows you not only to determine what is the optimal legal standard, allows you also to check or compare the actual standards in your jurisdictions with the optimal legal standards, to conclude whether the case law is right or wrong, whether the case law therefore would need to evolve and the standards would need to improve in order to make sure that we don't over-deter or under-enforce. Thank you very much.